Good afternoon. We're now on the record and video streaming. I'm calling this evidentiary hearing to order. This is for docket number 22-CONS-3046-CPEN. This is in the matter of the failure of Fuel Source, Inc. as operator to comply with K.A.R. 82-3-120. I'm Dwight Keene. I am chair of the Kansas Corporation Commission. I'm joined this afternoon by my fellow commissioners, Susan Duffy and Commissioner Andrew French. I will serve as the presiding officer for this hearing. Let's begin this afternoon with the entries of appearance, and I'll begin first with commission staff.
Thank you, Chair Keene. Kelsey Marsh on behalf of commission staff and the public generally.
Thank you. And for the operator Fuel Source.
Chris Steinkamp with the Pugh Gillenrath and McIntyre for Fuel Source Inc.
All right, very good. Does the staff have any recommendations regarding notice?
Yes, notice of this hearing was contained in the presiding officer's February 25th order setting an evidentiary hearing in this matter for Friday, March 25th, 2022 at 4:00 p.m. via the Zoom video conferencing platform. The presiding officer's order was properly served on the parties. Staff further notes that operator and operators counsel are in attendance today. Based on these facts, staff recommends the commission find that notice is proper and that the commission has the jurisdiction to hear this matter at this time and place.
Are there any objections to notice? Hearing no objection, very well. Then I will find at this time that the notice is proper and that the commission has jurisdiction over this proceeding at this time and place. Let's now move on to preliminary matters, and then we'll discuss the procedures for the hearing. Before we discuss some of the other preliminary matters, let's review a few of the procedures that we are becoming very accustomed to with Zoom proceedings. First, of course, we're conducting this over Zoom, and sometimes things can go wrong. If any party encounters a technical issue, please just ask to go off the record. Then we will resolve the technical issue before going back on the record. Second, witnesses are asked to keep their microphones off or muted when they are not scheduled to talk. And if everyone would mute their cell phones and phones in their offices and other electronic devices, that would be very much appreciated as well. Third, so that the parties are aware that if the commission needs to consult among themselves, we'll go off the record. The commissioner will enter into a Zoom breakout room and discuss what we need to, and then return from that breakout room and go back on the record. Fourth, since we are doing this by Zoom, please be especially careful to identify exactly what you're referring to if you're discussing pre-filed testimony or any filings. We have copies of all of that on hand, so we should be able to follow along if you can help us identify it. Do the parties have any other preliminary matters they would wish to take up at this time?
Yes, Chair King. It's staff's understanding that a hearing brief was filed in this docket yesterday on behalf of the operator. Staff's going to object to allowing that hearing brief into the formal record for consideration. And staff has a couple of reasons for that. First is the commission hasn't set a briefing schedule or ordered briefs to be filed in this matter. Staff does not believe that the document was properly served on staff. If it is a brief, then it seems that it's based on facts that aren't in evidence. Generally, briefs are for discussing legal issues, and it does not appear that any legal argument was asserted in the document. Filing the document the day before the hearing does not allow staff an adequate time to review and respond to the document. And all of the information that staff could tell was filed in the file document was available at the time operator's testimony was due.
Mr. Steinkamp?
Well, Your Honor, the point of filing the brief was to hopefully shorten our time here today and save everyone time. I don't intend to waste the commission's time, and I don't really want to waste anybody else's time with this matter. Our point is, frankly, one of equity, not necessarily one of law. And therefore, I would have to disagree with counsel for the commission. I think there are some legal points to make, but they are of an equitable nature and not a legal nature. And so for that reason, we've not contested the facts as the commission has established them, nor their assertion of a penalty under the circumstances. But our argument, frankly, is You may well have the power to do it. We think it's not the right thing to do under these circumstances. And I can elaborate on that if you'd like, but that's kind of the point. And I'm ready to kind of make a very brief argument to explain why I think that's the case. And if you want to entertain that now or at some other point, that's fine with me.
Was it your intention, Mr. Steinkamp, to offer this document that you provided yesterday, either in addition to or in lieu of an opening statement?
In addition to, I think, and I guess the point I want to make is that counsel for the commission, as well as John Myers, the hearing officer, and I have had some conversations about whether there was a potential procedure whereby we could submit some sort of a statement and just present this matter to the commission sort of on the record, if you will. And it was my understanding that that wasn't really a procedure that was possible. And so I was sort of directed to proceed in this way, not necessarily with the brief that I filed, but nonetheless to just present a statement, if you will, on behalf of Fuel Source Inc. at this hearing.
Marsh?
I don't have anything to add beyond, kind of the points I've already made.
Okay. Mr. Steinkamp, there's several concerns that I have. One is there are a number of factual assertions that are made within this document. The late filing of the document, incidental to the hearing itself, the absence of an opportunity for opposing counsel to either object to or provide any other arguments that they may present. I'm going to sustain the objection. And in the event that you wish to do some form of post-hearing brief, of course, that can contain whatever you wish. I have no limitation whatsoever. I'm not intending any on your opening statement either. So with that being said, let's turn to, let's see, first of all, let me go back to the procedures for the hearing. Are there any other preliminary matters that we need to take up? Well, hearing none, I'm going to proceed then with the overview of the procedures for the hearing. As we've already alluded to, the parties are characteristically allowed to make opening statements. After the opening statements, we have examination of witnesses. After direct examination of each witness, there's an opportunity for cross-examination, commission questions, and redirect. Any further examination beyond that will be at the discretion of the commission. Following these examinations, the parties typically make closing statements and arrange for the filing of post-hearing briefs if you believe it's necessary at that time. And then we'll conclude the hearing. That's the overview of where we're headed this afternoon. So let's begin with opening statements. And in that respect, I will turn first to Mr. Marsh.
Thank you, Chair Keene. Staff does not have an opening statement.
Very well. Mr. Steinkamp, please.
Thank you, Chairman. This is a matter that has bothered me a lot. And the reason that this is in a somewhat unusual posture, I suppose, is that we recognize that there are probably not facts that exist that cause the facts found by the commission to be in error. And there are probably not regulatory laws, rules that apply directly to this matter that cause many of the conclusions reached by the commission staff to be in error either. However, we believe that the application of the facts, the application of the rules to the facts that are here in the situation that we find ourselves in is very troubling. And we all learn in law school that there is no injury without a remedy at law. And our position is that the commission should consider the effect of the staff's position in determining whether it should uphold that position or not. We feel that it is inequitable and frankly reaches the wrong result under the facts of this matter. I think that it is not a dispute that Fuel Source has been defunct. It is an out-of-state corporation. It's been defunct since October 15th of 2020. Mrs. Freeman, who is on the phone and is not on the Zoom, inherited ownership of this from her husband, who passed away in an untimely manner in 2013. She did not have any control over the operations or funds of Fuel Source Inc., which were controlled by a gentleman in Kansas. And the corporation has been forfeited. And so what we're here to talk about is, after the corporation was forfeited, the license with the Kansas Corporation was also forfeited, and the commission has brought this penalty order against Fuel Source Inc. And I understand that the point of that, and I think everyone here would likely agree, that the point of that is that there are wells that were shown under the operating license of Fuel Source Inc. that have not been plugged. That's it. That's recited in the facts of the commission's penalty order. That fact is in dispute. What I think is important to know is that the reason that we're all here today is this started a year and a half ago or so with a penalty order relating to a mechanical integrity test, which penalty order was ultimately paid. And the reason was the mechanical integrity test was conducted after the period of time that it was due. It was conducted by an individual here in Kansas who'd been doing all of the operational matters for Fuel Source Inc. Before, during, and after Mr. Freeman's death. And Fuel Source chose to pay that penalty at the time. Following that, this penalty order came forth from the commission for the failure to renew its license. And as you know, by that point, the Fuel Source was defunct. So the real issue behind all of this is the existence of these unplugged wells. And I spoke with the conservation director, Ryan Hoffman, at the time of this penalty order being entered, and he suggested that I file this appeal of the order to raise this issue, and also to give the staff and my client an opportunity to try to work something out. And we've worked on that. We have tried unsuccessfully to sell these wells at auction, and they received no bids. We have also obtained proposals from licensed plugging contractors in the state of Kansas and attempted to reach a settlement agreement in which we would cause those wells to be plugged, with the understanding that we could make a claim under the new plugging fund as established by the revised plugging statutes, specifically KSA 55-180 sub D. And that idea was rejected as well. And so we're sort of at a loss to conclude how to solve this problem. And my concern is that penalties appear to continue to flow from the commission in spite of the factual circumstances that are well known by the commission. And I guess I felt like it was worthwhile to bring this matter forward and provide the opportunity for the commission to review the way this matter is being handled for this specific circumstance, and determine if that sort of a policy is appropriate under the circumstances. We feel it's not. We feel it results in an injustice because of the unusual circumstances. Now, I believe me, I fully understand that everybody out there has a sad story. And our point isn't to say that we're, we're just a bunch of sad stories and that's kind of the deal. But this is a somewhat unusual story that doesn't appear to be well addressed by the policies that the commission is currently using to address unplugged wells. And so we felt it would be worthwhile to raise this with the commission. Because Fuel Source Inc. is defunct, the commission's plugging funds are going to plug these wells at some point. We were willing to do the legwork to make that happen currently, with the understanding that the commission's plugging fund would be responsible for paying it, as it likely will anyway, almost certainly. Unfortunately, that idea wasn't a successful resolution. So, here we are. I guess one other point that I would make is I am appearing here and have been involved in this matter without charge to Fuel Source Inc. or Mrs. Freeman. It's kind of a put your money where your mouth is matter for me. We have in the past tried to do what I believe is the right thing. And the last time we saw something like this with the problem of unplugged wells, Joe Schremer and I wrote a law review article about that issue. This time, this is the manner that I feel like is the way to address bringing this matter before the commission. So with that, like I said, I don't feel like there is a factual dispute about the facts on the ground. I don't think that there is a legal dispute as to whether or not the commission has the legal authority to take the action it's proposed to take. I do feel, however, that it would be an unjust and inequitable result under the circumstances. Thank you.
Thank you. Mr. March, opening statement. We've had that. Let's turn to the examination of witnesses here. Mr. Marsh, if you would call your witness, please.
Yes, thank you, Chair King. Staff would call witness Nancy Borst. Chair King, are we going to have anybody swear in?
Yeah, my apologies, Chair Key. You'll need to swear in, Ms. Borst.
That's no problem. Nancy, if you'd raise your right hand, please. Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Thank you.
Thank you, Chair King. Ms. Borst, please state your name for the record.
Nancy Horst.
Ms. Borst, by whom and in what capacity are you employed?
I'm an administrative specialist for the Kansas Corporation Commission in the Conservation Division, Legal and Licensing Departments.
And what is your work address?
266 North Main Street, Suite 220 in Wichita, Kansas.
Are you the same Nancy Borst who caused to be filed in this docket direct testimony consisting of 5 pages?
I am.
Was this testimony created by you or at your direction?
It was.
Now that you are under oath, do you have any corrections or additions to make to your testimony?
No, I do not.
If I asked you the same questions contained in your testimony today, would your answers be the same?
Yes, they would.
Do you swear the answers contained in your pre-filed testimony were and are true to the best of your knowledge?
Yes.
Thank you. At this time, I would move for the admission of Nancy Borst's direct pre-filed testimony into the formal record.
Is there any objection?
No objection.
Without objection, it is admitted. Thank you.
Thank you, Chair. At this time, we would tender the witness for cross-examination.
I have no questions.
All right. Let's see if we have any commissioner questions. I'll begin first with Commissioner French.
No questions. Thank you.
Commissioner Duffy.
Good afternoon, Chair Keen. I have no questions as well. Thank you.
All right. I have no questions of the witness either. So that pretty much dispenses with redirect and recross. I think, Nancy, we appreciate your appearance here this afternoon. You may virtually step down. Thank you very much. You're excused. Mr. Marsh, any other witnesses for you?
Checking.
Mr. Steinkamp, as I understand it, your client didn't submit any pre-filed testimony and you don't have any witnesses. Am I correct on that?
You are correct, sir.
Okay. It's a very unusual circumstance. I think I understood from your opening statement the reasons why you wanted to have a hearing here. I think you wanted to bring some process questions before the commission. Is that correct?
Correct.
What is the relief, Mr. Steinkamp, that you're seeking from the commission?
Well, that's a good question. I think that it would be to the benefit of certainly my client and also, frankly, to the state of Kansas to proceed along the lines of some of the proposed resolutions of this that we've made, with the idea of going and having these wells that are really at issue here, even though this is a question about a renewal of a license, having those wells plugged and having what we had proposed was essentially an agreement with the commission that we could short circuit the, essentially long process of having the plugging contractor go through the, reimbursement process, if you will, that we would all agree up front who's going to go plug the wells, how they're going to do it, and that once they had done it, they would be paid. And then that would resolve this matter once and all for everyone. And we wouldn't have 3 unplugged wells sitting out there that clearly aren't going to get in any better condition as time goes on. And it would be done, and there'd be no further need for anybody to do anything here.
Mr. Steinkamp, if I understand it correctly from even from your opening statement here, the penalties that have been levied here have been levied against a defunct entity. Isn't that correct?
That is correct.
Do you have a copy of the penalty order handy?
I do.
Would you take a look at ordering clause D with me?
Which one?
Ordering clause subpart D.
Correct. Yes. The capital D on page 3, is that the one you're referring to?
That's it, yes.
Okay.
Let's take a look at subpart C of that. And let me read from the penalty order. Staff is directed to place the wells on the appropriate state plugging list, to plug in according to the priority as funds allow, and to assess the plugging cost to the operator. This shall not preclude the staff from investigating additional potential responsible parties. Have I read that correctly?
You have.
If, hypothetically, if you had not filed for this appeal and for this hearing, in the ordinary course, what in your judgment would have happened if ordering clause D subsection C would have operated on its own?
Well, my understanding of what would have happened would be that these wells would have been placed in the queue, if you will, and they would have been ranked as a priority, which I don't know what that ranking might have been. My understanding from the staff was that it was not of sufficient magnitude that they would be plugged anytime soon. I don't know that anybody quantified what that means, and I'm not aware of what that timing was. My point and my proposal was to cut short that problem and avoid, creating a further issue as these wells may decay over time, or who knows what else may happen. And so I don't know, but I believe you're exactly right that the staff would have put them on the plugging list, and at some point in the future they would be plugged. And they would undoubtedly charge the defunct corporation with the cost of doing so.
Let's assume that actually did happen. Then it would be the state's responsibility to determine the priority for plugging in accordance with its own procedures and vis-a-vis all the other wells that may be in the queue. Wouldn't that be correct?
Exactly.
So, I'm wondering why isn't that the solution?
Well, may well be, frankly. I guess that in my opinion, the injustice that we have here is there seems to be plenty of wells out there that need to be plugged. I mean, there's been as many as 20-some thousand. I think the commission has now determined that number, at least those that imminently require to be plugged, and I'm not sure exactly how they came to those numbers, but is something in the neighborhood of 6,000. I don't know what priority these wells would receive in that list of 6,000 or 20,000 or any other number. My point was to proactively solve the problem as opposed to continuing to define a defunct corporation that was inherited following her husband's death by a widow who lives in Arkansas and really had no connection or no knowledge about any of these matters. That was really my point. And that's the reason I guess I'm kind of here, if you will.
Okay. This has been lawyer to lawyer conversation here, a little bit out of the ordinary. I grant you that. I'm just trying to see if we can't fashion some kind of a result here and reach some kind of meeting of the minds. I'm going to go ahead back. I want to go back to the ordinary course here. And I think the next phase would be for us to turn to closing statements. And Mr. Steinkamp, I would turn to you first if you would care to close.
Okay. Thank you very much. I appreciate all of you spending some time this afternoon with me. Like I said, I think this is a matter that I consider to be important. It bothers me. I feel like it's inequitable. I think it could be addressed by the commission. Therefore, I've chosen this as a method that may be clunky. It may not be well thought out, but it's the method to bring this to your attention, and I appreciate your time. I think we've discussed this in some detail, as you pointed out, on a lawyer to lawyer, fairly high level, and I appreciate that opportunity. I would only say that I understand Kelsey's objection to the brief we filed. I would ask that our brief be considered a post-hearing brief, if that would be acceptable and of interest to the commission. I think we've had our piece, we've said our piece, and I would commend this matter to the commission's discretion. Thank you.
Very well, thank you. Mr. Marsh?
Thank you, Chair Kane. Staff just respectfully request that the commission affirm the penalty order for unplugged wells on an expired license. Thank you.
All right, thank you. Do either of you have any desire to do any post-hearing beyond the suggestion that Mr. Steinkamp has suggested? Mr. Steinkamp, anything beyond that?
No, I don't intend to file anything other than the brief that I filed, and I would just ask it be considered to be a post-hearing brief.
All right, Mr. Marsh?
If the commission does decide to consider Mr. Steinkamp's brief as a post-hearing brief, then I think I would at least ask for maybe like a 2-week deadline to potentially file something. I don't know that we will, but at least that allows me time to discuss it with my client and see if there's anything worth responding to.
All right. Let me think about this a bit. I am disinclined to tell counsel for either side what the contents of a post-hearing brief should contain. So my inclination is to accept the brief that you've filed, Mr. Steinkamp, as your post-hearing brief, if that would suffice for you.
It would. Thank you very much.
Now, in the interest of time, I'm trying to do that, Kelsey, so that you may now determine whether or not you wish to file any post-hearing briefs. Do you?
If I can have a 2-week deadline to potentially file a brief,
We'll grant that. We'll grant that 2 weeks from today. Any brief that you may have post-hearing will be due. Gang, I think this concludes our hearing. At this time, we will close the record and we're going to adjourn. I want to thank all of you for your participation in this hearing. Be safe.
Thank you very much.
Thank you all.